It's Vijaya back with another insightful edition of the Immigration Hour brought to you by Nockman Fulvani Zimovchek, NPZ Law Group, the full-service business and family immigration law firm in New Jersey, New York, and Indiana, with offices in India and Canada. And Snehal Batra is managing attorney at NPZ's Raritan office. Hello, Snehal. Welcome.
Hello, thank you so much. Namaste.
Namaste, very good to have you. So Snehal, what or who is a CPR in the immigration parlance? And I know it's not the one given to resuscitate someone, but what really are the consequences to those CPR who separate and divorce during their 2-year conditional resident status?
Sure, Vijaya. So first of all, the conditional permanent resident or conditional resident is an individual who receives a green card through marriage to a U.S. citizen or green card holder that is less than 2 years old at the time the green card is approved. Okay, so they're going to receive a green card that is valid for only 2 years versus a green card that's valid for 10 years. There's no difference between the green cards, okay? The only difference is that they have to file a joint petition with their spouse that they obtain the green card through to remove the conditions on their residence. You have to file a form I-751 within 90 days of the second anniversary of obtaining conditional resident status. It is a joint petition, which means that both spouses must sign the form, and if there is an interview, they both have to attend the interview, okay? Couples who have been married for 2 years or longer, when they receive their approval of the green card, they don't have to go through this extra step in this process, okay? Interestingly, Congress added this conditional residence in 1986 because they were concerned that many marriages between U.S. citizens and green card holders and foreign citizens may be what we call sham marriages, where someone marries another person just to get a green card and then divorces shortly after that. Okay, so this conditional resident status was created to deter marriage fraud. And so by filing the joint I-751 petition, you're proving to the government that the marriage is still valid, and you provide joint documents, including tax returns, bank statements, children that you have together, to prove that this is still a viable relationship, okay? And so if the parties cannot file a joint removal of conditionality because maybe they're divorced, okay, during this 2-year period, or they've separated, they have to request a waiver of the joint petition requirement, because if the parties are no longer together, then your spouse is unlikely going to sign the joint petition, right? So there are many scenarios in which the joint filing of the I-751 is not possible, and you have to request the waiver. Okay, so the first ground for waiver is if the marriage was entered into good faith, but the parties are divorced. Okay, so if you are divorced, you still can file, you have to file, in fact, that you're requesting a waiver. This is actually the most common scenario for waivers. You would file the petition on your own as a conditional resident. You submit your final judgment of divorce with an explanation as to why the parties separated, okay? The second ground for waiver is if the conditional resident would suffer extreme hardship if they're removed or deported from the U.S. So extreme hardship could include what's happening back home, loss of career, education, family ties. So that's the second ground. The third ground is if the marriage was entered into good faith, but the conditional resident was subject to abuse. So here you have to prove that the marriage was legally entered into in good faith, but the conditional resident has suffered abuse. Okay, maybe we have police reports, hospital records. So that's another basis of the waiver of the joint filing requirement. Okay, if the waiver is denied, you have the option to refile the waiver. And so like most immigration applications, the I-751 waiver can be approved if it's thorough, well prepared. And so your listeners out there, if they're in similar situations, they still need to file. They should give us a call to explore the possible waiver, and we'd be able to help you.
Wow, great information right there. And thank you, Snehal. That's Snehal Batra of the NPZ Law Group, your one-stop shop for the entire range of US and Canadian immigration matters. Don't hesitate to reach out to them. Log on to visaserve.com or call them today at 201-670